So, Sir's courtroom is always packed with lawyers who are keen on learning the law and understanding the vital point of arguments. Justice Endler's journey inspires all young lawyers. He began his career as a at a solicitor's firm and later transgressed into a law practice in Delhi, where he mastered usances of real estate, family law, civil, and arbitration law. Wherefrom he was elevated to the judiciary in year 2008. Justice Enlaw is presently occupying the roster of Division Bench 4, Ordinary Original Civil Jurisdiction and Commercial Division of the High Court of Delhi. Justice Enlaw has decided several suits relating to intellectual property rights, real estate and disputes, landmark judgments on HUF and Hindu succession law. One of one judgment of Sirs I wanted to mention was the case of Vikram Behel and others versus Siddhartha Behel, wherein he decided an important aspect of mutual will, and he observed the principle of mutual will coming into effect and binding also the testator who may still be alive on the death of one of the two testators is well enshrined in Indian law. I welcome you, sir, and the esteemed expert speakers at our webinar.
Thank you.
We are also keen to introduce Dr. Pinky Sharma, Associate Professor of Law Center 2 of the Delhi University. She was awarded a doctorate for defending her thesis of Operation of Legal Rights of Hindu Female in Modern India. She has written extensively on women rights and Hindu laws over the years. She started her career in the year 1989 as a lecturer in a university and soon shifted to law faculty of Delhi University way back in 1996. Her expertise in the international law, principle of contract and marriage, divorce laws, and family laws. Dr. Pinky has been awarded the University Research Fellowship in Law for a remarkable contribution to the field of law. She has frequently published in National Capital Law Journal of Gurdeep Singh, International Law Macmillan India Limited editions. Dr. Pinky has many such notable accolades in the fields of law. I welcome you, ma'am. I would also like to take this opportunity to introduce Ms. Kadambari, who herself is a very experienced lawyer. She'll be introducing the topic of session today. I welcome you, Kadambari, a very seasoned lawyer. Over to you, Kadambari.
Thank you, Rubinder.
I would like to just interrupt in a moment. Kadambari must give us a treat for hailing over a judgment which the High Court has held on electronic evidence, and that judgment of family law has been recorded everywhere. I congratulate you, Kadambari, for the same.
Thank you, Rubinder. That's just a judgment, and we have our esteemed speakers. And thank you so much for introducing our esteemed speakers who we were so much looking forward to hear. And one thing I particularly wanted to add is that Justice Endlaw is a maverick when it comes to super expeditious disposal of suits or writs. Over the years, his judgments have taught us that the procedural law solves essentially all problems on the original side. One often finds cases listed before him wrapped up at a very preliminary stage. In fact, whenever we appear before him, we don't know the outcome. And the cases which are decided are on the basis of such unchallengeable technical points, which neither the parties nor sometimes even their counsels would have contemplated. There is a lot of learning of law from your judgment, sir, and welcome once again, sir. And Dr. Pinky Sharma, a well-known educator, holds vast qualifications and knowledge on the subject, yet shares her knowledge with such humility and warmth, as I've experienced recently during my interactions with her. A heartfelt welcome to both our esteemed guests. Now, going forward with the subject matter, a fundamental characteristic of property is that it cannot be without an owner. After the owner's demise, the property has to transmit to a successor, another person. And this act of transmission is what we refer to as succession. And this is where succession laws have developed. Now, the world over, the laws of succession have commonly adhered to twin principles, twin concepts of testamentary succession, where a person has left a will specifically bequeathing his property to certain persons of his choice, and interstate succession, where a person dies without making a will. Then his property is acquired by his legal heirs as per the interstate succession laws of the land. Now, Hindu succession laws over a period of time have developed somewhat differently from the rest of the world due to the existence of a very unique feature, which is peculiar to Hindus in India, a Hindu joint family, which is without a parallel, as they say, in the ancient, in any other ancient or modern civilization. And the succession laws of Hindus have traditionally been connected to this particular institution and the practices. Traditionally, there were two schools which would define the rules of succession, Mitakshara and Dayabhaga. Now, they are not so relevant. However, just to touch upon the same, both the schools, Mitakshara was more widespread, except for Bengal and Assam. Mitakshara was prevalent across India. And both systems were largely male-centric, and women had almost negligible rights. Now, Mitakshara system recognized two modes of devolution of property. One was by devolution by survivorship, and second by succession. Now, as per the rule of survivorship, which has almost been abrogated now, upon the death of a co-parsoner, now co-parsoners, which as I understand are 4 generations of male members in a continuity who have acquired interest in the joint family property by as a birthright. So when a co-parsoner would die, after that the family properties would devolve upon other male co-parsoners, and if his not on his wife or daughters, and if there was a son, and I may be corrected by our esteemed speakers, if there was a son who was beyond those 4 levels of continuity, then even the son would not inherit. But his separate estate would devolve as per the succession laws, again, largely to the exclusion of women. Now, the concept of testamentary rights was also almost absent as far as the traditional Hindu laws was concerned. Due to the complexity of the Hindu succession rules, the British launched into an extensive codification drive. And this is one very interesting historical fact I would like to share. The first code which came out was a code of Gentoo laws. Because when English came to India, instead of Hindus, they called the natives Gentoos, and they thought all were Gentoos, Hindus, Muslims. And the first code which was brought out was a code of Gentoo laws. After that, this was further amended, and the first real enactment as far as succession laws was concerned was in 1937, when widows were given a limited right in the estate of their deceased husband, but they could enjoy it only during their lifetime. After 1937, finally, as far as succession laws, of course, Indian Succession Act was also enacted, which primarily governed the testamentary rights, the self-acquired properties. And after that, it was in 1952, finally, that some limited rights were given to women. And finally, in 2005, that women were given the status of equal co-parsoners as that of Hindu males. Now, with this backdrop, let's launch deeper into the subject matter by gaining an understanding from our esteemed speakers about various nuances of Hindu succession laws as they existed, and also their relevance now. So the first question for Justice Rajiv Enlaw, sir. Sir, the terminologies which often come up in the context of Hindu succession laws tend to create a lot of confusion. For instance, Hindu joint family, how is it different from Hindu undivided family? What are co-parsoners and what is co-parsonary? Ancestral property, notional partition, these are the words which come up. So after 2005 amendment, since we are dealing with the current laws, the current relevance, so what is the relevance of these terms as of now, and the differences between Hindu joint family and HUF? What is the notional partition? Is it now relevant? Kindly clarify our concepts here, sir. Thank you so much.
Good evening, everyone. And thank you, Kadambari. And thank you. I think I don't see Rupinder. He seems to have disappeared, having done his bit. Kadambari, actually, you've placed me on the same platform as a academic, and I'm quite frightened always to share a platform with the academic, because our knowledge as lawyers can never be as deep and as vast as of an academic who has devoted. And in a few minutes before this, when I spoke to Professor Sharma, her subject is family law. So I'll speak, ma'am, but you always would be right in correcting me, because we should disseminate correct information and nothing wrong. Now, see, this problem is about these expressions. What has happened is that these expressions are used in a very loose sense. The words joint Hindu family, ancestral property, parsonary property are terms of the original Hindu law, what you said, the concept of Mitakshara co-parsonary. The other two terms which you have mentioned, Hindu undivided family and notional partition, these are terms which have grown out of codified law. So I'll deal first with the uncodified law, the ancient Hindu law as we call it. And what I have found in the last about 13 years is that most of us who are born, I'm of course born, I'm also born after the coming into force of the Hindu Succession Act. But most of us remember the ancient Hindu law, and everybody forgets the codified law. So I'm proceeding to deal with these three terms of the ancient Hindu law with a rider that we have to understand it in today's context. Now, joint Hindu family was a common state of a Hindu family in the ancient times. So when it was said that joint Hindu family, it meant all common descendants from an ancestor, and which would include the daughters as well as the wives of the sons and grandsons and great-grandsons. So a joint Hindu family was a much larger concept than a co-parsonary. Co-parsonary was a, having said what was a joint Hindu family, now the next term is co-parsonary. Now co-parsonary was comprised of only those out of the members of a joint Hindu family who got a share by birth in ancestral property. Now, we have to be very clear, because this is another very common thing which one has come across in the last 13 years on the bench. A lot of people feel that ancestral property is all property which has come from the ancestors. The ancestors can be male as well as female. So I think I must have come across at least 8 or 10 suits in these last 13 years, where people have filed suits for partition, claiming that my father got this property from his mother, and therefore it is ancestral property. So when we talk of ancestral property in the context of ancient Hindu law, ancestral property was only the property which was inherited from males and in which the son of the male got a share by birth. And you mentioned about 4 generations, but let me clarify that even if suppose that if we talk of theoretically that there were 5 generations living. That though it would be very rare. And at the time when the ancient Hindu law was in force, the life expectancy was also not as much as we have today, and that explains the retirement age, which was fixed of 58, because by the time you attained 58 years of age, you were supposed to have lived past your prime and not be of any use to the society, which is not so now. So, but if there were to be a 5th generation living along with the earlier 4 generation, then that 5th generation also became part of the co-parcenary. It's not as if the 5th generation did not become a part of the co-parcenary. So co-parcenary only meant a lineal descendant, a male lineal descendant who gets a share in ancestral property by birth. Even under the old Hindu law, if a person inherited a property from his mother, then that person's son would not have a share in it by birth. It was only property traversing from the male lineage in which, so they constituted a co-parcenary. And this concept, to a certain extent, when, see, we did away with this, and what used to happen about co-parcenary was that the inheritance of the share in the co-parcenary, because see how it worked. There was A, the father, B, his son, and then B had 3 sons, C, D, and E. So each one of them would get 1/5 share, A, B, C, D, E, or whatever, 1/6 share. And then when the succession, the survivorship used to be per stripes. So if A died, then his share would devolve between the other B, C, D, and E. It would not go to others. Then similarly, when B died, his share would devolve to the others. But amongst, after that, when if you had more than one son, then it was per stripes that your branch will get. But the share was always forever changing of the co-parcener in the co-parcenary. When the Hindu Succession Act came into force in 1956, they did away with this concept of the son getting a share in the property inherited by the father from his own father. So if any property was inherited by a son from his father who died after 1956, and the son had not been born during the lifetime when the grandfather was alive and had property, then he would not get a share. I hope I am clear. Let's use the ABC concept first. A was the B inherited the property from his father A, who died say 1960. Now B's son C was born in 1961. So C will not get a share in what B had inherited from his father, from A. On the contrary, if C was born in 1957-58, the grandfather died in, no, it would be, sorry, I think I've said it wrongly. It had to be that he had to have acquired a right if he was born prior to 1956. Yeah, I'm sorry. If C was born prior to 1956, before the Hindu Succession Act came into force, then C would have acquired a right in the grandfather's property. And even if the grandfather died after coming into force of the act, the old law would apply, the Mitakshara law. But see, now today in 2020, we have very few cases of that kind. What we find most of the people filing cases is that of the grandfather having died, post 1956, after the coming into force of the Hindu Succession Act, of the father having died, after that, the son being born, after the after 1956, they blindly follow the case of they file suits for partition saying, I have a share in the property by birth. But which is not so, because the Hindu Succession Act changed everything. They changed the concept of the son inheriting a share in the property of the grandfather by birth. So today it is not there. Now, is there any clarity in that?
Yes,
Now
sir.
that leaves one term which you dealt, which is of notional partition. And no, sorry, HUF is also. HUF was a concept brought in by the Income Tax Act. So HUF was a narrower entity than Hindu undivided family. To HUF, the Hindu undivided family, the principles of the co-partitionary applied, but you could be forming, if suppose one of the members of the co-partitionary had his private property. Now that it was open to that co-partitioner to form a HUF with respect to that property, either along with his brothers or along with his sons. It was again confined to males. The females were excluded from HUF also. So HUF is, as I said, it's a part of the codified law. It's a creation of the income tax laws. Now, notional partition, which is a term applicable to Mithakshara property, because Section 6 of the Hindu Succession Act introduced this term, notional partition. So they wanted to give a share in the co-partitioner's, dying co-partitioner's share to his wife and daughters also. So they said that, all right, the co-partitionary is not disrupted on the death of a co-partitioner, but the share of the co-partitioner has to be determined. So that's why they said that there is deemed to be a partition at the moment of his death, so that his share does not go by survivorship. It is determined that, all right, there were 5 co-partitioners, his share was 1/5. That 1/5 will be divided. That was treated as his individual self-acquired property, and in which his mother, his wife, his all children, whether male or female, had an equal share. So broadly speaking, these are the several meanings which are there. These are the meanings which are there of these several terms.
Thank you, sir. Thank you, sir. Now our next question is, since daughters are equal co-parceners by virtue of the Succession Act 2005, and Section 6 was amended, a daughter was given equal share. She was made the co-parcener, however, excluding partitions or alienations of property which had taken place before 20th of December 2004. Now, what is meant by the term partition or alienation of property before 20th of December 2004? Why this specific date? And to take an example, supposing the daughters had signed an unregistered relinquishment deed prior to this particular date, 20th of December 2004, and the property had already been divided amongst the mutated. In fact, it was entered into the mutation records, the father and the sons only. Then after this 20th December 2004, can a daughter come forward to claim her share in the property still, notwithstanding that relinquishment deed or the partition which could be assumed on the basis of that mutation? So you're on the mute, sir.
Sorry. First of all, this date of 28 December 2004, this Amendment Act of 2005, this received the assent of the President on 9th September 2005. So it came into force on 9th September 2005. But why they related it back to 28 December 2004 was because the bill which led to this Amendment Act, that was in vogue since, I think that was tabled. If I remember correctly, it was tabled in the House on 28 December 2004. So on that date, it became public knowledge. Now, though it had been tabled, but it had not become the law, or it would not have become the law till the presidential assent came, and which takes some time, as it happened in this case. It took about 9 months' time from 28 December 2004 till that date. So there is always a fear that once it becomes public knowledge, people who wanted to deprive their daughters of the share or the benefit which was supposed to be conferred on them, they will deal with their property effects partition dates. So it was only to protect the persons to whom the benefit of the amendment was sought to be given, that they kept the date of the date the bill was tabled in the parliament from which it became public knowledge, so that there could be no transactions between them. Now, the other part of your question, that why there was this exclusion. See, the language of the amendment is that on and from the commencement of the Hindu Succession Amendment Act 2005, in a joint Hindu family governed by the Mitakshara law, the daughter of a co-parsoner. So the daughter of a co-parsoner means that the co-parsoner had to be in existence. At least that's how it's been interpreted. There is some issue pending with respect to that in the Supreme Court. But so what has been held, or what follows from the language, is that the co-parsoner had to be a living. There had to be a HUF in existence. If the HUF had ceased to exist, suppose before 28 December 2005, there had been a partition or the HUF had been dissolved, then where is the question of daughter becoming a co-parsoner in something which had already ceased to exist before the date the legislature sought to vest a right in the daughter? So that was the reason for that. Similarly, if the HUF continued to exist, or but had already divested itself of the property, that the co-parsoner or the with the consent of the karta with the consent of the co-parsoners had sold the property and received the sale consideration. So the right could only be with respect to that sale consideration which was remaining in the HUF. It could not create rights in things which did not exist. And if this provision had not been there, there would have been a possibility of the daughters making claims with respect to the properties which had already been sold, or the properties of the HUF which had already been distributed. So that was the genesis of this.
Thank you, sir.
Now, whether it is more retrospective, that question the Supreme Court will decide.
That is still pending before the...
Yes.
Right, sir. Thank you so much, sir. My next question is for Dr. Professor Pinky Sharma, ma'am. Ma'am, it took almost a century and very snail-paced amendments to finally give a color of gender equality to daughters. Now, would it be correct to state that now there are no more discrepancies, or are there still any discrepancies to reach that complete gender equality?
Thank you so much, Kadambari ma'am. Before I take up this question, I would like to thank Professor Justice Endlaw for appreciating academicians. Sir, academicians always have the apprehension that the lawyers and judges, they have the vast knowledge because they have the practical knowledge. So sorry if I commit any mistake while discussing any of the issue. Thank you so much, sir. Yeah, ma'am, you are right that the gender equality, this is in Constitution, there is a principle of the equality under Article 40. And moreover, as the women are concerned, they were considered to be the homemaker only. and the property belonged to the men, as you all of have studied under the ancient law and codified law. And she was, no doubt, to some extent, she was entitled to the Istridhan. And Istridhan again, which was Sodhaika type of the Istridhan, where she had the power to alienate that property also. For the non-Sodhaika, again, she was supposed to seek permission of the husband. She was always a wife of the co-pastor or widow of the co-pastor, and as a daughter she was entitled to the maintenance right of the marriage, etc. But the moment the daughter marries, she will lose a membership in the father's joint family and she shifts to the another family. In 1937, when the Hindu Women's Property Act 1937 was passed, the idea or the intention of the legislature was to improve the economic status of the female, because in case the co-partner dies, in that even rule, as per the rule of the survivorship, property devolved upon the surviving co-partners only, and she was looking towards the co-partners only just for the maintenance, and she was given meager amount just for the food, shelter and the clothing. In that even 1937, she stepped into the shoes of the deceased husband. That means in case a co-partner died, leaving behind his widow, that she is entitled to the share of the husband. The rule of survivorship, by which the property will have devolved upon the surviving co-partner, that was suspended during the lifetime of the female. But she was a limited ownership of the property. Under three situations, she could alienate the family property to meet with the requirement. That was legal necessity, performance of the indispensable duties, etc. Apatkale, Kutumbharthe and Dharmarthe, these were the three terms in our Dharma Shastra. She could not alienate otherwise. In Hindu Succession Act 1956 was passed. In that even the day that lady, she slept with the limited ownership of the property. When she woke up on 17 June 1956, she became absolute owner of the property. Only thing was that she was possessed of the property. That means she has not alienated otherwise. Even if the repossession was there, she became absolute owner. You see, when the codification was being done, in that event also there was a conflict, whether because the daughters or they were not included in co-partnery, they were not getting anything in the ancestor property. So the orthodox view was there that no, son should become the co-partner, he will get the ancestor property. So that idea was upheld, but with certain changes under section 6, where she being the class 1 here, she was entitled to inherit the property of the interstate. Then again, the legislature, they were not silent. They thought about the improving the economic status of the female. Kerala was the first state. In 1975, Kerala Joint Family Abolition Act was passed, because in order to improve her status, two things were possible. Either we should abolish the joint family system, or we should include the daughters into co-partnery to meet with the requirement for the principle of the equality to both the sexes. Kerala took this initiative. Joint family system was abolished, which was enforced from 1976. On the date of the introducing of this amendment, all the families, they divided. Presumption was the partition has taken place, and all the families, they became the nuclear family. Now other states, they were taking it otherwise, that why not the daughter should include, because the role model was created by the Kerala government. Second role model was created by the Andhra Pradesh government. Andhra Pradesh, Tamil Nadu, Maharashtra and Karnataka. In 1989, 1985, 1989, 94 and 94, they included unmarried daughters into the capacity. They took an initiative, they took a bold step to include the daughter, but discrimination was there between the unmarried daughters and the married daughter. Maybe the reason that the orthodox view was there, if daughters are included, then she may herself may not ask for the property, but at the instance of the husband or the in-law, she may be compelled to ask for the partition to claim her share in the family property. So these states amendment, they were just for the improvement of the economic status of the daughter. keeping some that discrimination between the married and the unmarried daughter. Finally, we got the central legislation, which was an amendment in the Hindu Succession Act, which prevailed over all the state amendment, thereby daughters, irrespective of the marital status, married as well as the unmarried daughter, they were included into compulsory, and that was given in the bold letters that daughters are included in compulsory. That was a great idea, but when we give a reading to the section 6, when the sons who were co-partnered, who had the right by birth, and now the daughters, they have been included into co-partnery with all the incidents of the co-partnery. This is very important. Incidents of the co-partnery are applicable for the daughters who are included in co-partnery. Now, when they were giving something to the daughter, something has been, much more has been given to the sons. If we give a reading to the section 6, otherwise generally the rule of survivorship is applicable when a co-partner dies. But the provision to the section 6 that if the intestate dies, leaving behind any one of the class 1 female here, or the male inheriting to the female that was the daughter's son, in that table, notional partition will be there, presumptive partition will be there, as if before his death he asked for the partition. In that event, these daughters, along with the other class 1 female here, which are actually 8 in number in the 12 years in the 1956, they were getting this property and rule of inheritance was applicable. But when this amendment has been made, the rule of survivorship for the male intestate has been abolished under all the circumstances. And as far as the daughters are concerned, the rule of survivorship is still applicable. If the daughter dies undivided, property will devolve on the surviving co-partner. But in case she is married, in that event, property will go to the sons and the daughters, or the children of the predeceased son and the predeceased daughter. So rule of survivorship has been retained for the daughters, which has been abolished for the male member. Another very important thing is that she will get the property with all the incidents of the co-partnery, which includes right by birth is there, and then unity of the possession, community of the interest is there, payment of the debts is there, everything is included. Now, specifically it is mentioned that sons, they are no more responsible for the payment of the debts of their parent. Otherwise, under in Dharam Shastra, it is mentioned sons' pious obligation to pay off the father's debts. But for the daughters, because she will get it through the incidents of the co-partnery, it will be there. Another thing is, when we see to the section 8, the class 1 here the spouse of the son is included. But when we give a reading to the section 15 of the Hindu Succession Act, in that even, until unless this is the separate property, self-acquired property, or it is received, inherited from the parent, from the in-law, source of the property is very important. And in case she dies without the husband or the children, property will go to the heirs of the husband. In no other personal laws, we will find out that the heirs of the intestate, they are based upon the sex of the intestate. Here the intestate is a male, class 1 here is a different category. For the daughter, it is different. It is generally the husband, children or the grandchildren, and in their absence, even the separate property goes to the heirs of the husband. And if she has inherited the property from the father's side, and it goes to the heirs of the father as if he died, or the husband as if he died. That means section 15 of the Hindu Succession Act in the Bombay High Court, a constitutional validity was also challenged, as if the legislature, they were not clear whether the daughter independently she can retain the property or not, she can take care of the property or not. That's why just if she dies without the husband or the children or the grandchildren, property will go back to the source from where she has inherited the property. But as far as the co-partnery property is concerned, where she has been included as a co-partner, in that event, again, discrimination is there. Spouse of the daughter He may be a bona fide person, he may be the genuine person, but he cannot get the property which she received as a co-partner. And as far as the children are concerned, only they can get the share of the undivided or the divided, whatever is the case, the daughter as the co-partner. These are the technicality problems in the amendment, but practically also I don't think, because generally this is a custom in our family whereby that after the marriage there are so many things, functions happens at the family of the daughter or the brother, where generally the family member, parents of the brother, they come with certain gifts. Take the example of the marriage of the children. Bhat ceremony is there, and in case the daughter, she claims share from the brothers, from the co-partnership property, and they refuse, she goes to the court. That will always will be the spheres of the relationship with the family member. Generally, it happens that the daughter, they will write down that I don't want anything from the father's property, because she is too emotional. She wants that she should have the continuity of the relationship with the bhai, brothers and brothers and bhabis, etc. And moreover, as far as the sorry as far as the property is concerned, there are certain tribes where the tribal customs are applicable, and the tribal women still they have no right to inherit the property of their parents. So discrimination to some extent is still there, but this is again the perspective how you take up the things. Thank you so much, ma'am. कादम्बरी मैम, आपने अभी आप म्यूट में हैं.
There seems to be a small technical glitch at Kadambri's end. She has not been able to. So Kadambri would just join back from a mobile phone right now. Her laptop's giving some trouble. So apologies for that, please. Rubinder, can you take over in the meantime, please?
Rubinder, you are also muted.
Manoj, am I audible?
Yes, now you are.
Grateful. So my question to you is, till the time Kadambri comes back, so there is a Supreme Court judgment in which it has ruled that even a married daughter has a right to parents' property. Would I request your lordships to kindly address on this proposition slash ratio of law behind it?
See, that's been the settled position under the Hindu Succession Act. A daughter, whether married or unmarried, was given a share in the parents' property. The rule of inheritance for property of the mother and the father is the same. So there were only some restrictions about a dwelling house, which existed earlier, that earlier a daughter inheriting a share in a dwelling house could not have sought a partition of the same. She could have got a share only when her brothers decided to partition it. Now that was done away with by the 2005 amendment, but there are still certain restrictions which continue under the Transfer of Property Act. Section 44 bars a right of joint possession to a purchaser, and under the Partition Act also. But otherwise, now a daughter can seek a married daughter also can seek partition of her share in whether it's a dwelling house or any other property which she inherits from her mother or father. So there is nothing new about it. That has been the law.
So grateful to your lordship for such a self-explaining answer. It's been very well explained. Ma'am, Pinky ma'am, may I just put a question to you, ma'am?
Yes.
Ma'am, this is of transgender. Ma'am, am I audible to you?
Yes, sir.
Ma'am, against the spirit of the constitutional provisions as provided under Article 14 and 15, transgenders have no space for any succession or inheritance in India. They are still governed by the customary law. After passing the Transgender Person Protection of Rights Bill in 2016, still there is no provision regarding succession rights of transgenders. But now the families are not giving. Ma'am, could you please throw some light on this, ma'am?
Yeah, sure. You are absolutely correct that the Transgenders Act of 2016 is passed, but they have not touched to the right of the inheritance. And you are right that way that these days the families, they have changed their mindset. They don't give the child to those communities. Earlier, when the transgenders were being handed over to these communities, as per the custom which are applicable in those communities, it was always the guru who will inherit the property of his chela who dies without any will. But as far as the transgenders are concerned, when they are being brought up, they are being getting education also. Even for the educational institution, there is a strict direction that the admission can be given to, we should be given to these transgenders, and they are getting it also. And they are trying their best to settle in their life, facing so much struggle in their personal life also. And the transgender, when generally they are brought up as the male member. And in the Hindu families, if they are not handing over that child to the communities, bringing up as a male boy, so he should be presumed as a male child only. And in those cases where they are bringing up the child as a daughter, so in that even sections which will be applicable, that will be she will be the class 1 here, just like the male boy. And if she dies interstate, in that even section 15 and the 16 of the Hindu Succession Act will be applicable. So transgenders as such, they are not getting any law of inheritance. It should be there. There should be a change. Thereby, they have the specific law related to that. And moreover, we can't go through the even for the birth certificate, but the bringing of the child as a male or as a female, that will decide how the law related to the inheritance should be applicable. Thank you.
Thank you so much, ma'am. Over to you, Kadambari.
Yeah, thank you. And sorry for the glitch. My screen just froze. So thank you for pitching in, Rupinder. My next question is from Justice Endlaw, sir. Sir, I'm giving you a situation here now that the concepts we have spoken about. A Hindu family comprising of a father, mother, and 2 sons, and a daughter also, form a company. The daughter is not a part of formation of a company. They form a company which is duly incorporated under the Companies Act. Can the business of the company be also construed as a joint family business? Now, if the family decides to partition the business amongst the 2 sons by a registered family settlement, can they do so, since company is essentially a separate juristic entity? Can still the sons and can it be treated as if there's a partition of the business? So you're on the mute.
Sir, you're muted, sir.
Kadambari, you'll have to tell sir he's on mute.
Yeah, sorry. There is the concept of a private limited company is entirely different, and there is no owner of a private limited company. A private limited company is a juristic person. So just like there cannot be an owner of a human being, similarly there is no owner of a company. There are owners only of the shares in the company. So you cannot say that the company is owned by the family members. You can say that the shares in the company are owned by the family members. And the person who is holding the shares, he is holding it on the behalf of other members of the family. Now, with effect from 1986, I think, we have this Benami Act, which does not permit that. But there is a provision in the Companies Act for making a declaration. If suppose a HUF is holding the shares, then a declaration is required to be made by the person in whose name the shares are held, that I am holding it on behalf of the HUF, naming the HUF, or that I am holding it for the benefit of X, Y, and Z persons. So now the next is, so that answers that whether there can be a ownership of a company. Ownership can be only of the shares in the company, but you have to watch out for the Benami laws and you have to comply with the requirements of the Companies Act about the declaration. Now the next part of your question is about, but the business remains of the company. You as shareholders, then you see there will be a question that how do the shareholders, if the shareholder is holding it on for the benefit of somebody else, how does that shareholder vote in the meetings, annual general meetings of the company? Or if he is also a nominee director, then how does he conduct his business? So for that, the other members who have been declared as the beneficiary will have to institute a suit if they are differing from how the shareholder who is holding the share is acting, to compel him to act in a certain way. But they cannot go to the company and say that it has to be like this, because the company recognizes only the person in whose name the shares are entered or who's on their board of directors. Now, as far as partition is concerned, there are different ways. You cannot split up a company. We can have the schemes of merger, demerger of a company. So if suppose there are more than one businesses, then the two businesses can be demerged, the shareholdings can be transferred. The schemes which are sanctioned, which earlier used to be done by the company court and which jurisdiction has now gone to the NCLT. So that would be the way to partition, or you dissolve the company and distribute the assets. These can be the ways to divide it, but you cannot say that it is, I'm partitioning the company.
Right, sir. Thank you so much.
Just if I may add one thing, see, it's not as if Joint Hindu family does not recognize a business. There was a concept, there was a lot of development of that case law in the earlier years under the Partnership Act, that there was a concept of Joint Hindu family trading firm.
Okay, yes, sir. Yes,
so the Joint Hindu trading firm carrying on business, that was governed by the provisions of the co-parsonery. Just because it was a firm, it was not governed by the Partnership Act. So that's where the principles came, because there, for instance, I remember some cases that the question arose whether the legal proceeding lapsed or not. So a plea was taken that no, it was a Joint Hindu family partnership firm, and therefore there was no question of the proceeding lapsing or abating on the death of the person who was suing. So business is recognized by the ancient law, but it had to be carried in that fashion. As a corporate entity, you lose that advantage. You have that benefit only for the shares.
Thank you so much, sir. This clarity was, I think, was required by a lot of participants who had sent their queries on specifically this particular situation. Sir, another situation, if I may put up to you, supposing a property is purchased in the name of one co-parsoner, but the proceeds come from a family business, where there is actually an HUF formed and there is a recognizable joint family and a joint family business is carried out. From their proceeds, the property is purchased in the name of one of the sons. To the extent of only, there are two situations. One, only 25% of the corpus is put, rest is put by the son, who's probably working elsewhere also. And one, that the co-parsonary pays the entire corpus. Can the other co-parsoners claim such a property in either of the two situations?
Again, it's a matter of proof. There can be no, they can claim, but if the property is in the name of one of the co-parsoners, to be entitled to a share in it, you have to first show that the intent was to acquire the property for the benefit of the co-parcenary or for the benefit of the Hindu undivided family. As I was saying that today there is the concept of HUF is encountered much more in the courts than the concept of, because HUF can be a separate legal entity. And earlier when the taxation structure, when I say the taxation structure, I mean the Income Tax Act, that there were benefits in having as many accessible entities as possible in a family. So there are a large number of cases today where there was no ancestral property as such, but for the purposes of managing wealth tax and income tax, the father, when he built a number of properties, he would also build a HUF and then declare a HUF, form a HUF, because HUF can be formed. It's not as if there are no 4 generations or no ancestral property, there can be no HUF. There can be no co-parcenary, but you can still create a HUF by either in writing or even by conduct. So there are a lot of number of cases, because in 60s and 70s, a lot of families constituted a HUF, putting the property in the HUF. So there this question arises very often. But then you have to show that the intent was to buy for the HUF, the consideration flowed from the HUF, and it was always treated as the property of the HUF. The conduct also becomes relevant. So these 3 tests have to be satisfied. Otherwise, as far as the Transfer of Property Act is concerned, the ownership of the property vests in the title holder, that is the person in whose name the sale deed exists. Now, the other thing which you put about 25%, that 25% can, even if the HUF has contributed 25%, it can also be by way of a loan. The presumption would be that when a property is purchased in the name of a co-parcener, that it is a self-acquired property and 25% is only a financial assistance or a gift which has been given by the HUF to that co-parcener. And then you will also have to prove, because under section 45 of the Transfer of Property Act, if the property is in the name of several people, now here we are not even talking of several people, we are talking of property in the name of co-parcener only, then it is open to you to prove that you are owner to the extent of the contribution to the price. But section 45 also requires transfer in joint names. So in that case, you will have to prove that, look, 25% ownership was intended to be of HUF. It was not a financial assistance.
Thank you, sir. Thank you, sir. That gives us a lot of clarity that the intent is ultimately intent and conduct has to be
Yes.
primary feature, and the other factors also in construing that intent. So another question is, can an undivided share in immovable property be acquired through which is there in a joint Hindu family property? Can that be sold off? And if you inherit after in an interstate succession where you've not yet got the property, then I suppose it can be sold off. But when you have an undivided interest in a joint Hindu family property, can you sell it off to a third party?
In a joint Hindu property, the sale can be affected by the co-parcener only. So there, for a co-parcener to it can be affected only by the karta, not co-parcener. So if you are a karta, you stand on a better footing, but if you are a co-parcener, then but that karta also will be selling the property or a share in the property, not his personal share.
Yes.
Otherwise, it's a body. The property exists as a whole, and the shares could be fluctuating. But yes, a co-ownership share can definitely be sold.
Okay, sir.
On that, there is no bar. The bar is with respect to a dwelling house only, which was done away with under the Hindu Succession Act. Some restrictions remain under the Section 44 of the Transfer of Property Act and Section 4 of the Partition Act.
Thank you so much, sir. So my next question is to Dr. Pinky Sharma. Dr. Sharma, after supposing there is a person and after his demise, his widow files a partition suit, then during the pendency of the suit, she gets remarried, even the decree is pronounced by the court. Will she be entitled to her share at that time, or will she lose her inheritance? You are on the mute, Dr. Sharma.
Sorry. Thank you so much, ma'am, for this question. You see, the status of the heirs to the property belonging to an interstate under Hindu law, that is determined on the date of the opening of the succession. Opening of the succession means the date on which the interstate dies. The property actually may be divided later on. It can be postponed, but the status is determined on that particular date. Under Hindu Succession Act, we had Section 24. There are actually 5 categories of the widows as far as the class 1, class 2 heirs are concerned. One is the widow of the interstate, second is the widow of the son, predeceased son, and another is the widow of the predeceased son of the predeceased son. That means son's widow, grandson's widow, interstate's widow, father's widow, that is the stepmother in the class 2, and the brother's widow, she is also in the class 2. And status is determined there. But at the time of the codification, they have excluded brother's widow and the father's widow. And they have taken over only 3 categories of the widows whose remarriage will be the decision to inherit the property of the interstate. And those widows include now son's widow, grandson widow, and the brother's widow only. And this particular situation which you are taking up, that the widow, she has filed a suit for the partition. She was still the widow of the interstate. When the interstate died, she was there in the family itself. After putting that, filing that particular petition, she remarried. Subsequent remarriage will have no impact. It happens for the other categories of the widows also, whereby she remarries after, maybe even after the 2 hours of the death of the interstate. But at that time, she was the widow of the son, grandson, or the brother's widow. In that event, she will be entitled to that share to which she belongs. That is that she belongs to the class 1. Second thing is Section 24, which dealt with the remarriage of the 3 categories of the widow, has been deleted from the Hindu Succession Act by the Amendment Act of 2005. The question is whether it will have any impact otherwise. Absolutely no. It is not written, but it has been deleted. Reason being, the relationship of these widows, son's widow, grandson widow, the brother's widow, that arose with the interstate due to the marriage with the son, grandson, and the brother. The moment these ladies, they remarry, so that particular relationship has been severed. And moreover, they were included into the list of the here just to provide some sort of the maintenance, because they are the widow of these relationships who were very close to the heart of the interstate. The moment they are remarrying, in that event, they have the right to get the share of the property belonging to the second husband. So retention or the deletion of the Section 24 will have no impact as far as the right of these widows to inherit the property is concerned. The moment remarriage takes place, they are not entitled to that, but that will be determined at the time of the death of the interstate. Thank you so much.
Thank you so much, ma'am. My next question to Justice Endlaw, sir. Sir, this particular question has been asked by many of our participants. This relates to testamentary succession. In most of the states, it is generally understood that getting probate of a will is not mandatory. And many a times mutation is effected in the revenue records on the basis of the will. Are the rights of the beneficiaries secure in such cases?
Yes, to claim a right in inherited property under a will, it is only in the presidency towns that it is essential to obtain a probate of the will, which being Bombay, Calcutta, and Madras. Otherwise, it is not essential to obtain a probate. And there was some doubt about this proposition till recently, because there was a judgment of 1962 of the Supreme Court, which without going into the question of application of that part of the Succession Act only to presidency town and to certain religious sections only, had proceeded to say that the right cannot be claimed because probate was not obtained. There were judgments of this court and of our predecessor court, that is the Punjab court, saying to the contrary. But now the matter has been placed beyond the pale of doubt by a three-judge bench judgment of 2019 of the Supreme Court, where they have said that that 1962 did not consider those provisions of the Act, and therefore it is not good law, and there is no need for a probate. So today there is no doubt or any ambiguity on this.
So may I ask the name of the judgment, this 2019 judgments for the judgment for the benefit of?
I won't remember the name. As far as I remember, it is Justice Nageshwar Rao's judgment or his bench. I don't know who has penned it, but it's probably penned also by him.
Sure, sir. Thank you so much. Sir, now there is another situation deriving from this question only. Supposing a duly registered will of A is discovered after 12 years of the demise of the testator. The will is found from the office of a chartered accountant after his demise. So the person has died 12 years hence, but the chartered accountant with whom apparently this registered will was kept, a copy of the registered will, but it was registered and this was the original will. It was discovered. Now the property had been bequeathed by the testator to his caretaker and not to his family members who never stayed with the testator. Now, what would be the position if, one, no letters of administration had been filed by the natural legal heirs of the testator to claim their shares, or the second situation where the letters of administration had been filed and had been granted also to the legal heirs. Now, here is a registered will and the original is also there. This is, what if we, because this directly, since there is no probate, and how would this situation unfold?
See, there is a question about limitation for applying for probate.
Right, sir.
So there are, I think, one or two judgments which say that it has to be applied for within a limited time from the date of the demise or from the date the need therefore arose. But now in the light of this 2019 judgment, which says that it is not necessary. So once it is not necessary, the question will arise that the limitation, even if applicable, will be from the date of the cause of action. Now the factual situation which you have placed, now the practical aspect of it is that after 12 years, the caretaker is not going to be around. He is unlikely to be in contact with the chartered accountant. So he would never come forward to claim. But if suppose the caretaker was to discover and then he was to make a claim, he'll have to prove that he was not aware of it at any earlier point of time. He became aware then only. And if he is not in possession of the property, then the better course would be to sue for possession from whosoever is in possession of the property to recover back the possession, and in which the issue with respect to the existence and validity of the will be decided. But since 2019 has clarified, I think limitation has to be counted from the date of the need for a probate arose, or a need for claiming a right on the basis of the will arose, and that will depend upon the nature of the right which is asserted. And under section, the article with respect to declaration would apply, that the date on which the cause of action for seeking the declaration first arose.
Thank you, sir. Sir, may I also further ask now on testamentary succession, what are the common mistakes that lawyers and litigants?
See, I'll tell you, I think I've shared this on one of the earlier platforms also. I'll tell you of an actual case. One probate had come up before me for final disposal after perhaps 9 or 10 years of the institution. There was voluminous evidence, and I just started hearing arguments, and I was flipping through the pages, and I asked the counsel that which page is the will. So when I saw the will, it was witnessed by one person only. So I immediately stopped. I said, but this is not a will. So how can probate be granted to you? So the counsel said, yes, I know. So I said, if you know it's witnessed by one person only, why did you file this probate? Now what had happened, that will was with respect to a house, which under that will probably of the father had bequeathed exclusively to the son who was claiming the probate. So I said, why are you pursuing this for 10 years? So he said that actually this was filed by some other lawyer. They came to me only about 1 or 2 years back. And since it had been going on for 8 years, I thought if I tell him now, he'll think I'm a fool. So I said, all right, it's gone on for so long. Nobody has noticed it. There is no objection on this ground. So I asked the counsel for the respondent who was objecting to the probate. I said, are you aware of this? He said, yes. So I said, why did you not take an objection in your objection petition? He said, I am in exclusive possession of the house. If I had taken this objection in my objections, the petition would have been dismissed immediately, and he would file a suit for partition against me. So I thought, let him enjoy the ride. I'll stay in the house. So see, this is again, once we are sure that it is not necessary to obtain a probate, you have to see which is the best course of action for you, depending upon your facts, that whether to apply for probate or to apply for a substantive relief. If suppose in this case, what I just mentioned, the will had been in favor of the son who was in possession, he was in exclusive possession, he would have been fully justified to, if at all any brother was asking for a share, to file for probate. If suppose a brother or sister had given a notice, so the cause of action would have started running. So he would have been right in claiming a probate. But if the brother who was disputing the will, if he wanted, and who was out of possession, if he wanted to claim a share or even exclusive possession, then it is better for them to not apply for probate, but to seek the substantive relief of partition or possession. See what happens. If you say there is no will and I have inherited a share, then even when you get up, even if the probate of the other side is dismissed, you start a partition suit, there will be so many other defenses in a partition suit of a partition having already been effected, or whatever else the lawyers with their ingenuity will build a defense so that it go for evidence. So the decision whether to go for probate or for a substantive suit, because the will can be proved or unproved even in a substantive civil suit. So a person who is wanting to claim anything in possession of another, even if the other is setting up a will, should always go for a substantive suit. In this case, even if suppose he wanted to prove the will and he thought that, all right, it's witnessed by one, I'll take a plea the sub-registrar who registered the will. I'm just giving different situations, should be treated as the second witness, or the lawyer who has said that he has drafted the will should be treated as the second witness. Instead of having all that proved in a probate case, he should have filed a suit for possession, so that in the meanwhile, he would have proved the will as well as dealt with any other defenses to the, instead of after probate, then going for another substantive proceeding. So there is no hard and fast rule, and if there is no dispute, then there is no need for a proceeding. If everybody is at item that there is a will or there is not a will, you don't need, because then everybody can just give affidavits that yes, there is a will, we accept the will, and as per the will, the property should be mutated in the name of the person who is the beneficiary. Then you don't need to spend that kind of money also.
Right, Your Lordship. Thank you so much. In fact, I remember a long time back when I was a very young counsel, we had filed a partition suit, and I had prepared the my client that, look, it may take a few years or it may be decided early. Let's see, there were two brothers not on talking terms with each other. And I remember that time it had been listed before Your Lordship, and we got the preliminary decree when only the written statement had been filed. So this was again on the basis of admission of certain documents which are there. And I think that client still continues with me, thinking that I've done the job. But
I'm glad to hear that.
Not sure. Sir, there's another. Now, the next question I'd like to ask Dr. Sharma. Dr. Sharma, if we ask you to list out the essentials of a valid will, what would it be? And supposing we have a lot of lawyers and non-lawyers with us, what are the essentials that are a must to be followed for a will to be valid? You're on mute, Dr. Sharma.
Thank you so much, madam. Yes, the person who executes the will, first of all, his eligibility is very important. He should be of the age of the majority, and he should be of the sound mind. That means the person who is of the undeveloped mind and underdeveloped mind, they are not eligible to execute a will. Second thing is, it should be in writing with the signature of that individual executant, or if he is illiterate, in that even the thumb impression will serve the purpose. Second thing is, another requirement is that there should be two adult witnesses to see that executant, that they should not be the beneficiary of that will. And another issue, if it is in writing, that it is okay with the attestation. But the most important thing is the registration of that will, that will serve the purpose. Because a copy of that will be in the office of the registrar. There will be no changes, no fraud will be there, no, even the codicil cannot to that particular will. Thank you so much.
So my next question would be to Justice Endlaw, sir. Sir, would an oral will or a dying declaration made by a person be construed as a will? Can we prove that in a court?
See, only with respect to certain officials, a a person, I think what the statute says is that a soldier or a person on duty and who is at the war front, in his case, oral will is permissible, and that also lapses as soon as he comes back to safe areas. But for anybody else, there cannot be a verbal will. It has to be satisfying the conditions. So there are a lot of provisions in the Indian Succession Act. Unfortunately, that remains a very less read act amongst all of us. And I have also suffered once. I may add one thing which I learned the very hard way, that if you have executed a will before marriage, then on your marriage that will lapses. So there are, say, all these defense services, and in several services, you are required to make a will when you join. And the joining age is generally before the age of marriage. And after that, that will remains. So a lot of time, the mother or the father in whose favor the will is claimed at that time seeks rights to that to the estate on the basis of that will. But that automatically follows. So this Indian Succession Act has to be studied carefully by anybody who is practicing in this field.
Thank you so much, sir. So what are these, when it comes to the modus of proof, and if the will is admitted by the other party, then there is, I would say that there is no further need to prove it, as had fallen from sir in the last previous question. However, if it is not admitted, and supposing it is registered and the sub-registrar is called, and also perhaps if there is a mutation also which has happened before a quasi-judicial authority, and some evidence has been led over there, then in these two cases, would we still need to prove the will?
See, in a probate proceeding, you have to comply with the requirements, with the proof of the will in terms of Section 63, I think, of the Succession Act and 68 of the Indian Evidence Act. But in a inter partes proceeding, say a partition suit or something, if one of the parties sets up a will and everybody else agrees, then on the basis of admission, a decree for partition can be passed, or a decree for possession can be passed, or any other decree in accordance with that will can be passed, and it's not essential to prove it because that is an inter partes, doesn't affect anybody else. So between all of them, it would be an admission, and there is no need to prove.
Okay, sir.
But otherwise, a lot of people ask that what is the way to secure a will and not that it is not challenged. There are several ways nowadays. A lot of people record a video, but you have to take care that in that video, it should be evident that the testator or the testatrix is understanding what is being done. And it should be a wide camera video, that nobody is holding a gun to the testator or testatrix head. You have to prove that there was no undue influence. So there is no foolproof way, but yes, registration is a step up. Preparing a video is a step up. Having a certificate from the doctor, a lot of people deposit it with somebody else, and that deposit should always be under cover of a letter that I am forwarding to you this for safekeeping. Or a lot of people, what is advised is that you make a handwritten will, don't engross it or type it, so that it is evident that you have written it yourself. You could write it only when you are in a sound mind and writing 1, 2, 3 pages takes time. That it's your own volition, it's not under force from anyone.
Right, sir. Thank you so much. Dr. Sharma, this is a question which pertains to, again, Hindu succession laws. Supposing there is a renunciation or a relinquishment deed which is unregistered, which is signed by the sister in favor of her brothers, one of her brothers, not all. What would be the effect of such relinquishment, supposing the father was to die after such relinquishment is done? And this is one situation. And after that, we'll go to the second situation, and that is for sir. Now, sir, the renunciation having been done, however, if that same property is bequeathed by the father in favor of that particular child, which has already relinquished her share in favor of her sibling. So the first part of my question is renunciation, unregistered, and what is the effect in favor if the renunciation is in favor of one of the siblings and not all in a joint family property? And the second query is for sir. Dr.
Thank you so much. Madam, actually, renunciation of the share in the family property, and that should be in totality. That means renunciation the share of the family property should be in favor of all other affected persons. That means all other co-partner, and it should be for all the property. Pick and choose formula that I will get the share from the property which is in Delhi, and I don't want any share in the property which is in the small town. I would like to share my renounce my share in favor of X instead of the Y. That is not allowed. And moreover, the example which you are giving, the sister, she has renounced, that is possible in the co-partnership property after the Amendment Act of 2005 throughout India, or it is for depending upon the state in 85, 89, like Andhra Pradesh, Tamil Nadu, Maharashtra, and Karnataka. And the registration of the renunciation or the relinquishment of the share, that is very important, so that in future there is no such type of the issue which the other members they will face, especially whose share is being decreased.
Thank you so much, ma'am. Now, coming from this, sir, I would like to ask you, supposing the father has acquired certain properties and this renunciation is given by the daughter, and she even signs a registered relinquishment deed, if that is possible, in favor of her brother, saying that whatever I get out of my entitlement from my inheritance from my father, it will go to you. But subsequently, the father bequeaths it in her favor, and she files now for a probate on the basis of the will. The brother says that, look, there is a registered relinquishment deed that you had signed earlier of your unidentified share. In this situation, what would be the outcome? It's a very...
With respect to the self-acquired property of the father, during the lifetime of the father, the son or the daughter having a share does not arise. So there is nothing to relinquish. I have not really had an occasion to examine this, but what my understanding is as of just now is that that relinquishment is meaningless. You can relinquish only what you have, not what you don't have today and what you have a chance of succeeding. The father could have very well left it to the son also, so the sister will not have anything at all. So it is not possible. So therefore, even if she has executed a document like this, that would not affect the will in her favor by the father.
Thank you, sir. So one last question from me to you, after which Rubinder will ask a few questions.
Yeah, we have already exceeded our time.
Just one last question by me, and perhaps
yes,
you would have seen the chat also. So just a few questions from we'll do it very fast, sir.
Yes.
What is the amount of court fee payable on the memorandum? This is one of the participants who was specifically 2-3 questions have come on this also. What is the amount of court fee payable on the memorandum of appeal against the preliminary decree in a suit for partition on alleged joint properties? And if there are multiple properties, supposing 20 properties, How to value the suit for the purpose of court fee? A, if the plaintiff is not jointly holding the property. B, if the plaintiff is jointly holding the property.
See, the thumb rule is that the court fees in an appeal is the same as the court fees in the original proceeding. Now, what should be the court fees in an original proceeding? As far as Delhi is concerned, we have authoritative judgments to the effect that if there is a plea in the plaint that the plaintiff is in joint possession of the property, then at that stage, the plaintiff cannot be asked. An issue will be to pay the court fees, even if the defendant says that there is that I am in exclusive possession of the property, because the possession of one co-owner is for and on behalf of all the co-owners. So therefore, at the initial stage, you have to pay only the fixed court fees, even though, which happens very often in the case of married daughters, that they are not really in physical possession of any of the properties or in control of any of the businesses which belong to the father. But on the principle of possession of one is the possession of all, there is fixed court fees required to be paid at that stage. And if the defendant disputes that and an issue is framed and the issue is decided against the plaintiff, then at that stage, the plaintiff is required to make up the deficiency. Now, the situation of the plaintiff being in joint possession of some of the properties and not all the properties, there also a fixed court fees only is required to be paid, because as long as there is a jointness of estate, there is no such thing that you have to be in joint possession of each and every property. What Delhi High Court has held is that only if the plaintiff admits in the plaint itself that there is a complete ouster of the plaintiff from the properties of which the partition is claimed, or if on the basis of the documents or admitted pleadings of the defendant, it is evident that there has been a joint ouster of the plaintiff from the joint, there has been a complete ouster of the plaintiff from the joint properties, will the plaintiff be required to pay the court fees at that stage? Now, the court fees payable is the value for the purposes of jurisdiction is the value of the entire property, and the court fees payable is the court fees payable ad valorem on the value of the share claimed.
Thank you, sir. And may I request Rupinder to quickly run through the. Sir's already taken a lot of time. Sir, but just a few minutes.
I thought this is time bound. You seem to have booked it for longer.
So we always do, but we will take it.
Yes.
Sir.
You are muted, Rupinder.
You're on the mute.
Sir, with your permission, if you may just proceed a little further for asking some more questions.
Yes.
It's been actually such an interesting insight from both of the speakers, and in fact, Kadambari has covered most of the questions, just few of the questions more, sir, so that the lawyers can be more clear on this aspect.
Yes.
Sir, number one, sir, in fact, this is my own question, sir. I was just listening to you, sir. As your lordships have rightly given an example of armed forces officer, that they make their will at the time of joining, and that will lapses after marriage. So do we require an amendment in the statute to cover this lacuna, as many officers are ignorant about it?
No, see, ignorance of law is no ground. I think as long as the lawyers are not ignorant of it, it's all right.
Very well, sir. ignorance of
because
law.
Ultimately, the questions come to the lawyers.
Right, sir. Therefore, ignorance of law is not a bliss. Sir, my second question to you, sir, is, sir, this is on child disowned, sir. When a family disowns a child through notice in newspaper, generally done with ulterior motives, like to avoid payment of maintenance, etc. in divorce cases, will it after succession, will it affect succession rights of that child in future?
This question, there is a judgment of the Division Bench of Justice Bhatt of our court, where he has said that there is no disinheritance by public notice. Disinheritance can be only by way of a will, validly executed will. So, as far as Delhi High Court is concerned, that position is there. I am not conscious of any judgment of this. Maybe I think there is some observation, but I can't exactly remember that judgment, any judgment of the Supreme Court. But Delhi, this is the law, and that has been followed consistently.
Yes, I think this is mostly in domestic violence cases or where maintenance is asked.
No, actually, also people, there is a common perception that once I have issued a public notice of disinheriting a child, whether I make a will or not, that child will not get any share in my estate.
So, ma'am, Pinky ma'am, a question for you, ma'am. Registered gift deed is irrevocable. Donor has died after registration of the deed. During his lifetime, mutation had not been done. Donee applied for mutation after 30 years of his death. Other brothers objected for mutation. What is the remedy?
You see, as for the gift, you have rightly said that the gift is irrevocable. Generally, it happens when you execute a gift deed, the possession of the property, the subject matter of that gift, that is also transferred. Now, in this particular situation, when the mutation has not taken place, it may be the ignorance, like rightly we say the ignorance of law is not an excuse, that because the person was enjoying that property and there was a failure on the part of the donee to get it mutated also. And after 30 years, when he wants to correct it, another way, the brother of the family members of the donor, if they are raising objection, in that even to some extent, Limitation Act is also there. Limitation Act are within the for the movable property within 3 years in general, and for the immovable property it is the 12 years by which the objection should have been raised. So I feel this gift is valid gift.
Thank you, ma'am. Ma'am, one last question before I go on to the viewers' question, ma'am. If I convert into another religion or marry a non-Hindu, will I lose my rights in the joint family property as on date of my conversion?
Yes, there are 4 situations under the succession law whereby even if the person is not interested, automatically the status is severe. And those situations are, first of all, the child is given in adoption. His family, the right in that joint family will be severe. Second is the daughter gets married. And third situation is with a person marries under the special marriage act with a non-Hindu. Before 1976, even if you are marrying to a Hindu under special marriage act, the joint family status is severe. And yes, or the conversion, the day the person converts to some other religion, he will lose his membership in the joint family. No doubt, the person who is converting, his property right in that family property will be protected on the date of the conversion. Thank you, sir.
Thank you so much, ma'am. Kadambari, probably there's a problem in my, I'm not being able to see the questions. Oh, 1 second, I've got it. Just let me have a look at the chat. Just give me 1 minute.
If I may add, in the meanwhile, even by marrying under the Special Marriage Act, you cease to have right in the property.
My lord.
In the family property.
Yes, sir. For the
there
date
is a provision under the Special Marriage Act.
Yes, sir. But the question was for the conversion.
That's right.
Why I skipped it.
That's right.
But otherwise, the state property share in the family property, that is protected because of the Caste Disability Removal Act of 1850. From that day onwards, the conversion or the marriage under Special Marriage Act, the share in the family property is protected. Thank you.
Sir, there is one wonderful question from Kimi Badara. It says, sir, that can a limited right to live in a property during his/her lifetime be relinquished? Sir, am I audible?
Life estate.
Sir, I'll repeat the question, sir.
See, life estate is only for your life. So there is no question of your disentitling the ultimate beneficiaries. In the case of women under the Hindu Succession Act, there are judgments to the effect that it becomes absolute ownership. So that is a question which is still at large in the courts, that in what circumstances the limited right converts, for instance, if under a will executed prior to a post 1956, a limited estate is given to a wife, whether it would convert to absolute ownership or not. There are a lot of cases pending in the courts. Some have been decided, one has been decided, one or two have been decided by me, but the appeals are pending.
Right, my lords. So another last interesting question. In case father and a grandfather died interstate prior to Amendment Act of 2005, and property stood in the name of grandfather, whether a married daughter can be considered co-partnership as per Amendment Act, and whether she can claim partition of the property stood in the name of the grandfather.
See, Section 6 presumes there is a co-partnership. In the facts which you have said, there is no co-partnership. When the grandfather dies, his properties will be inherited only by the father. In the father's hand, they don't become an ancestral property or a co-partnership property. That's what I was saying initially. There is a lot of confusion about ancestral property. Just because the property, see, ancestral property, we mean anything inherited by us from anyone. So if your father has inherited a property from his grandfather, then you don't have a share in it by birth. You get a share only if your father dies intestate,
Right, sir.
or bequeaths a share to you.
Right, sir. Thank you so much, sir. Dr. Chandrasekhar, are you there? Dr. Chandrasekhar? I think with this, we can wind up. We have taken his lordship's lot of time, Pinky ma'am's lot of time. From lecture series on law, and I thank I thank Justice Rajiv Sahay and Law Sir, Pinky ma'am, and Kadambari. And before winding up, Kadambari, could you please thank everybody on from your end too? It's been a pleasure, and we apologize for the overtime taken.
Sir, heartfelt thanks to you, sir, and to you, ma'am, for so patiently asking and throwing light on different nuances of succession and inheritance laws. These were, a lot of practical situations that we had asked you to deal with, and besides, of course, the theoretical understanding of various concepts which arise out of Hindu succession laws. Thank you so much. And this was, we were all very eagerly waiting for this webinar. And, the responses that we have received by the registrants, by the participants, has been tremendous. Thank you so much, sir. And thanks.
Thank you so much. Thanks.
Thank you, sir. And
thank you, Dr. Sharma. Bye, everybody.
Thank you, sir.
Have a nice weekend.
Thank you.
Thank you so much. Thank you so much, Kadambari ma'am and Rupinder sir, for giving me an opportunity to share this forum with Justice Endlaw. Thank you so much, sir.
Thank
it was
you.
really interesting. Thank you.
Thank you, sir.
Bye-bye.
Thank you, ma'am. Thank you, Kadambari.
Thanks, Rupinder.